With submissions just closing for the Antisemitism Bill, Prime Minister Anthony Albanese barely gave Australians a chance to weigh in on the 500-page bill. Due to the short time frame, we took it upon ourselves to submit our own concerns to the Parliament for consideration, because many Australians in our audience simply have not had the time to read the bill nor make a submission. When this committee finally published our submission, they completely butchered it with black redaction boxes. Now, I don't know which bureaucrat on 300 grand stuffed that up, but get it fixed. We have a debate next week. When we called them to get it sorted at 4 p.m. on Friday, they said that they'll just have to get it sorted on Monday because the people who do the programming had already gone home an hour early. They dismissed it as a programming error. I mean, seriously, did you wait until the weekend to do this accident? Because come Monday, Tuesday, it will be too late for the debate and maybe even the vote. My name is Jammal, and for the last 4 years, I've been trusted with Turning Point Australia, thanks to Charlie Kirk and Nigel Farage. In a moment, I'm going to read out our submission to the Parliament on the Combating Antisemitism, Hate and Extremism Bill 2026, because I want to make sure that both you, but especially this committee, really get the message and no glitch gets in the way. Firstly, I want to thank the hard work of those in my team who managed to get our submission in before the tight deadline. I pray that this video informs Australians of the dangers of this bill, but also empowers you to help defeat the bill, which is set to be debated in the next few days, probably Monday or Tuesday. If you would like to download our 10-page submission without those stupid redaction boxes, I'm about to read the submission, but you can download it at tpaust.com.au. Please forgive the executive summary, which I'm about to read on our organisation. It's important in these sorts of documents that we introduce ourselves to these parliamentary inquiries so that they know who we are and what we do. But let's get into it. Submission to Parliament. Combating Antisemitism, Hate and Extremism Bill 2026, submitted by Turning Point Australia. Executive Summary. Turning Point Australia is an organisation dedicated to educating and assisting Australians in promoting freedom through political policy education, legislative analysis, and the creation of educational resources that support democratic participation. Its work includes political commentary and analysis designed to assist voters in understanding the consequences of government policy. Turning Point Australia is a registered third-party campaigner and one of the largest digital political communication organisations in Australia. Across its own and associated channels, Turning Point Australia has generated in excess of 1 billion views on social media posts and video content. It maintains just under 1 million followers across multiple platforms. In 2025 alone, it reached 221.8 million views. It is the largest third-party campaigner in Australia by social media following, and at the most recent federal election, its How to Vote card materials were downloaded more than 500,000 times. As a result of this reach, Turning Point Australia plays a significant role in contemporary political discourse, particularly through online publication. Its ability to operate depends on freedom of political communication and association, freedoms that are directly engaged and placed at serious risk by this bill. Turning Point Australia unequivocally condemns all forms of racial hatred and political violence. The terrorist attack at Bondi Beach was a grave crime that demands a serious and effective response. While the Jewish community was targeted, the attack affected all Australians. However, the legislation enacted in response to this tragedy must strengthen the rule of law and democratic resilience, not weaken it. Turning Point Australia is deeply concerned that the Combating Antisemitism, Hate and Extremism Bill 2026 has been drafted as a broad, omnibus bill combining fundamental changes to criminal law, speech and association offences, executive powers, firearm regulations, migration law, and intelligence frameworks into a single legislative package. The advocacy of violence, threats, intimidation, and property damage is already comprehensively criminalised under existing Commonwealth and state law. Rather than address a legislative gap, the bill introduces unnecessary and disproportionate expressions into the regulation of lawful speech, political association, and civil society participation. In its current form, it criminalizes speech based on subjective fear rather than intent or harm. It permits executive listing of hate groups without adequate due process. It allows adverse legal consequences to flow from past or overseas conduct. It exposes lawful political commentary, including debate on immigration and population policy, to criminal sanction. It creates religious carve-outs vulnerable to exploitation while failing to ensure consistent protection, and it risks criminalising political association and party formation. Turning Point Australia urges Parliament to withdraw this bill in its entirety and rely on the existing legal framework which already provides sufficient tools to address hate-motivated violence and criminal conduct without eroding democratic freedoms. Now, I'm going to take you through our 9 points. Point number 1. Existing Commonwealth law already criminalises hate-motivated violence. The Commonwealth Criminal Code already provides a comprehensive framework to address hate-motivated violence, threats and property damage. Division 80 of the Criminal Code Act 1995 criminalises advocating or threatening physical force or violence against individuals or groups, distinguished by attributes including race, religion, nationality, ethnic origin and political opinion. Section 80.2a, 80.2b, 80.2ba, 80.2bb, and 80.2be make it an offence where a person intentionally advocates the use of force or violence against a group, a member of a group, or their close associate, while being reckless as to whether that force or violence would occur. These offences require intent. They're limited to physical force or violence. They attract penalties already of up to 5 or 7 years imprisonment, including mandatory minimum sentences in limited circumstances. Section 80.2bc and 80.2bd further criminalise advocating or threatening damage to places of worship or property owned or occupied by protected groups. Additional Commonwealth offences already prohibit advocating terrorism, Section 80.2c, publicly displaying prohibited symbols, Section 80.2h, Section 80.2ha, using a carriage service to menace or harass, Section 474.17. Taken together, these provisions demonstrate that the Commonwealth already possesses extensive and effective legislative tools to address hate-motivated violence, threats and intimidation. Against this existing legal backdrop, the necessity and proportionality of introducing new speech-based offences must be carefully scrutinised. Point number 2. New hate speech offences based on subjective fear. The bill introduces new offence in proposed Section 80.2bf, criminalising conduct that promotes or incites hatred on the basis of race or ethnicity. Under Section 80.2bf 1c, liability arises where the conduct would, in all the circumstances, cause a reasonable person who is the target or a member of the target group to be intimidated to fear, harassment, or violence, or to fear for their safety. This offence is not directed at a gap in existing law. Rather, it represents a significant expansion of criminal liability beyond conduct involving violence or threats and into the regulation of lawful expression. Criminal sanctions may be imposed without intent, without harm, and without proof that hatred occurred. Such a standard is incompatible with legal certainty and creates a strong disincentive to lawful public expression. Point number 3, suppression of freedom of political communication. The bill defines public place so broadly that virtually all online communication is captured. Political commentary published via websites, social media, podcasts, videos, and articles is therefore exposed to criminal liability under proposed Section 80.2bf. Legitimate debate on immigration, population growth, multicultural policy, national identity, or social cohesion may be characterized as causing fear or intimidation, even where it is fact-based and non-violent. Freedom of political communication is essential to democratic accountability. Laws that deter lawful political debate undermine democracy rather than protect it. Point number 4, direct impact on civil society and political commentary. Turning Point Australia exists to provide political commentary and analysis. That's our purpose. Under the bill's framework, commentators, contributors, and speakers may face criminal prosecution and imprisonment for expressing views that are controversial or unpopular. This risk arises because online publication constitutes public conduct. Intent is irrelevant, and fear need not be genuine or objectively verified. The deterrent effects arising long before any prosecution, leading civil society organizations to self-censor or withdraw from public debate entirely. A democracy cannot function where lawful political commentary carries the risk of imprisonment. Point number 5. Retrospectivity and legal certainty. The bill permits serious criminal and regulatory consequences to flow from past conduct, including conduct occurring outside Australia, particularly through the interaction of the proposed hate speech offence and the hate group listing regime. Proposed Division 114A allows an organisation to be declared a hate group by reference to conduct that occurred before the commencement of this legislation, and in some cases, conduct occurring overseas. While criminal liability attaches only after a listing is made, offences such as Section 114A.7 may be triggered by membership, association, or support in certain circumstances where the conduct relied upon to justify listing subsequently predates the offence itself. In addition, proposed Section 80.2BF applies to conduct communicated in a public place, a term defined broadly to include online platforms. Taken together, these provisions create a framework in which past online publications, statements, or commentary may be relied upon to justify enforcement action, investigation, or executive listing decisions, even where that speech was lawful at the time it was made. This raises particular concern for Australians who've previously engaged in lawful political commentary online, including debate or criticism of government, immigration policy, population growth, multicultural policy, or social cohesion. Legislation that permits historical conduct to be reassessed under expanded criminal and regulatory frameworks undermine fair notice and legal certainty, which are core principles of the rule of law. Point number 6, executive listing of hate groups and absence of due process safeguards. Proposed Division 114A grants the minister the power to declare an organisation a hate group, triggering serious criminal consequences for membership, association, or support. The bill does not require prior judicial authorisation, procedural fairness obligations, clearly defined evidentiary thresholds, or robust meaningful parliamentary disallowance mechanisms. The concentration of power within the executive creates a substantial risk of arbitrariness, error, politicisation, particularly where listing decisions intersects with political association or public debate. Point number 7, political association, party formation, and democratic participation. Australian law has long recognised the importance of political association and political expression to representative democracy. The High Court has repeatedly affirmed the implied freedom of political communication, and Commonwealth electoral law expressly contemplates the lawful formation of political parties. The bill's listing powers, when combined with criminal offences for membership or association, can have the practical effect of criminalising political association, even in the absence of violence or incitement. While violence must be prohibited, suppressing political association through executive discretion undermines democratic participation and the constitutional principle that political ideas are to be contested through democratic processes rather than executive prohibition. Point number 8, religious carve-outs, radicalization risk and uneven protection. Proposed Section 80.2bf2 provides a defense for directly quoting from or otherwise referencing a religious text for the purpose of religious teaching or discussion. Turning Point Australia supports genuine religious freedom. However, in the context of the Bondi Beach terrorist attack, which authorities identified as being motivated by extremist ideology, rooted in radical interpretations of religious teachings, this carve-out raises serious concerns. The primary offence in Section 80.2bf1 applies only to conduct directed at groups distinguished by race, colour, or national or ethnic origin. Judaism is recognised as an ethno-religious identity and therefore receives protection. Other religious communities, including Australian Christians, do not receive equivalent protections unless conduct can be characterised as racial or ethnic hatred. This uneven protection risks undermining social cohesion and may create exploitable loopholes for extremist ideology. Point number 9, risk of abuse, uneven enforcement, and suppression of lawful participation. The combination of vague definitions, subjective fear-based liability, retrospective reliance on conduct, and broad executive discretion creates a framework highly susceptible to abuse and uneven enforcement. Where existing offences already prohibit violence, threats and intimidation, expanding criminal liability into subjective assessment of speech risks diverting enforcement resources away from genuine threats and towards lawful political expression. Australians are likely to withdraw from lawful public debate due to uncertainty and risks, diminishing political engagement and weakening public confidence in the law. And here are the final observations and recommendations. Turning Point Australia recognises that advocating violence is already criminal and should remain criminal. The problem is not a lack of law, but the unnecessary expansion of criminal liability into subjective speech regulation and executive control. The Combating Antisemitism, Hate and Extremism Bill 2026 is unnecessary, overly broad and structurally dangerous. Existing Commonwealth and state legislation already provides sufficient powers to address hate-motivated violence and criminal conduct. Turning Point Australia urges Parliament to withdraw the Combating Antisemitism, Hate and Extremism Bill 2026 in its entirety. It should rely on existing criminal law to address violence, threats and intimidation. It should avoid introducing new speech-based offences that undermine legal certainty. It should preserve freedom of political communication and association, and it should ensure executive powers affecting criminal liability are subject to strong judicial and parliamentary safeguards. Turning Point Australia welcomes the opportunity to participate constructively in further consultation to protect Australians without dismantling the democratic freedoms that define our nation. If there's any other opportunities to attend an inquiry or any other meetings pertaining to this bill, Turning Point Australia would like to be involved. Signed, Joel Jammal, Executive Director, Turning Point Australia. Congratulations if you got to the end of that. Again, who has the time to put a submission into the Parliament in a matter of days, especially in this economy? You're probably wondering, I understand that now, but what are we going to do about it, Joel? Well, the debate is going to be held on Monday and Tuesday, and hopefully by then they fix up this submission that they redacted wrongfully. We're going to see how this bill can be stopped in the Senate. With the debate going on Monday and Tuesday, we're going to see how this bill can be stopped in the Senate. Our eyes are currently on the Green senators, who are a bit shaky on whether they will or won't support the bill. We may need your help, though, to email certain members of the Senate to apply pressure. Please do keep an eye on our social media channels. We'll be making sure we post every day to keep you in the loop, uploading videos to make sure you have the latest news. But I want to thank my team again for doing this research in a timely fashion and putting this together. If you felt that you got value out of this video, please do support me and the team by heading to our website at tpaust.com.au. You can sign up purchase merchandise, or leave a donation to support our work. But above all else, share this video far and wide so your fellow Australians can learn about the dangers of this bill to our country. Because apparently they won't upload my submission without wrongfully redacting it. But I want to thank you for your time. God bless you, and I'll see you next time.